Yea. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Your name, your attendance shall be heard. Now, the State Commonwealth of Massachusetts Court is open. Please be seated.
Good afternoon, everybody. Welcome to the Appeals Court. I am Justice Rubin, I think, and to my right, Justice Henry, and to my left, Justice Hand. We are hearing a single matter this afternoon, number 22-595, Department of Children and Families versus Mother. This is an impounded case, so we don't use anybody's name. We refer to them by their role, father, mother, child, and so on. We have some housekeeping to attend to before we begin the argument, and I will actually ask Attorney Levin, who I see in the audience, if you could come to the podium, please.
Good afternoon, Justice Rubin.
Good afternoon, Attorney Levin. You've seen our detailed order of what procedures we're planning on following. Is that right?
Have Your Honor.
Okay. So we have allowed father's motion seeking to allow him to represent himself, and have allowed it on the condition that you will be present to serve as standby counsel. I want to ask you a couple of questions on the record, and then we'll do a colloquy with the father, who's, I'm not going to use your name because that's how this proceeding is, although your name will be on a sheet you sign, and we'll confirm all of that. But I'm going to ask you a couple of questions first, and then I'll ask him to come up, and I'll ask him a series of questions. Are there any changes you need to make to the facts averred in your most recent affidavit?
Except to say, Justice Rubin, that we've spent a significant additional amount of time together preparing for this hearing, no.
Okay, I don't know if it's necessary to modify it for that. Do you have any concerns about father's competency to waive his right to counsel?
I have no concerns about father's competency to waive his right to counsel today.
Very good, thank you very much. So we will now have the assistant clerk swear the father. So if you could come stand at this microphone at the podium.
Right here. Do you, Father, solemnly swear and affirm that the testimony that you are about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you very much, and thank you to the assistant clerk. We understand you wish to exercise your right to represent yourself before us, and I want to make sure you understand that the reason we're taking all these careful steps before that happens is to make sure that your rights are fully protected. That's our concern here. You absolutely have a constitutional right to represent yourself, and you also have a constitutional right to be represented by an attorney. The reason for that right, the right to be represented by an attorney, is to ensure that you're protected in a legal proceeding. So when you give that up, we have to make sure that you're doing so voluntarily and understanding your rights, and that you have the right to a lawyer, even though you're not going to exercise it, you're going to argue yourself. Do you understand what I've said so far?
Yes, sir, and I appreciate that.
Okay, so I'm going to ask you some questions, and then we will proceed with hearing the case. First, how old are you?
42.
How far have you gone in school?
9th grade.
Have you had any difficulty understanding what I've explained so far?
No.
Are you under the influence now of any alcohol or drugs, including prescription medication, that is interfering with your ability to understand what I'm saying or to make decisions right now?
No.
Has your failure to take any prescribed medication that's not really a sentence. Is that interfering with your ability to understand what I'm saying or to make decisions right now?
No.
Do you understand that you're entitled to a lawyer to represent you and to present your argument to us, and that Attorney Lavin is prepared to do that for you today?
Yes.
Do you understand that a legal argument is not the same as an argument made in other contexts, and that a lawyer, a person trained in the law, may understand the legal issues in a way a non-lawyer may not, and may be able to bring to the attention of a court problems with what happened in the lower court in ways that may not be apparent to a non-lawyer?
Yes.
Do you understand that if you decide to represent yourself today, you're waiving or giving up the right to have a lawyer argue for you?
Yes.
Do you understand that even if you waive your right to a lawyer now, we will require Attorney Lavin to remain as your standby counsel, and that if you decide while the hearing is going on that you'd like Attorney Lavin to help you or argue for you, we will allow him to do so, although we will not provide any additional time to you?
Yes.
Do you understand that once the hearing is over, your choice to represent yourself is permanent, as far as this hearing is concerned? As far as this appeal is concerned, you can't come back and ask to have a new hearing so that an attorney can argue for you?
Yes.
Have you had the time that you need to talk with Attorney Lavin about the possible challenges of giving up your right to have him argue for you today?
Yes.
Has anyone promised you anything or threatened you to persuade you to represent yourself today?
No.
Is it your choice today to give up your... You had to think about that. Did someone threaten or do something to threaten you or promise you something?
Not for this case here, but in the lower courts, I was there under fear, threat, and coercion. I was assaulted. I wasn't allowed into the court. I had to call 911 to get into my own trial. So,
but that's not for this hearing. No one has done anything that has, you think, influenced your decision by threatening you or force or okay. And is it your choice, I'm sorry, today to give up your right to counsel other than as standby counsel available to help if you would like?
yes.
Okay. I find that your waiver of your right to counsel is made intelligently and voluntarily, and that you are competent to make that decision. And the assistant clerk is going to present you with a waiver form. And if you could sign it, I will sign the certification, and then we will hold argument. So the record will reflect that the waiver of counsel was executed in my presence, and I have signed the certificate and made the finding that permits us to go forward. That's fine. The assistant clerk will take that. I guess we'll make copies that she'll have available to you at the end of argument to all of counsel, and of course it will be filed and entered on the docket, and it's an impounded case so that it will be impounded along with everything else, you know, because it has private information in it. All right, so as I say, the case we are hearing today is number 22-595. The rules in our court are each side gets 15 minutes and there is no rebuttal. And if parties are dividing their time, they have to let us know in advance. And my understanding is that on the appellant side, father will argue for 7.5 minutes and attorney for mother will argue for 7.5 minutes. And then we will hear on the appellee side from the AAG for 10 minutes and then for counsel for the children, for the child, 5 minutes. Is that right? All right. So, with that, you may proceed.
Good afternoon, Your Honors. My name is M. I am the living, natural father of B. My responsibility as a father is to make sure my child has a better life than mine, to be well-loved, safe, happy, and healthy. I was taken by social services as a 4-year-old child myself. Due to the years spent in various hospitals, group homes, foster houses, and facilities, one of my biggest fears is DCF or social services taking a child I have a relationship with, let alone one of my own. Federal dollars, Title IV funding is, in my opinion, the reason we are all here today. Greed, HIPAA violations, big egos, failure of duty, breach of contracts, forced contracts, perjury, fraud, and abuse of process are just the tip of the iceberg in this case. I have consistently completed every task and more on the service plan. I paid for a hair follicle test to the tune of $1,200 out of pocket, which irrefutably proved I was in sustained remission, consistent with my doctor's and counselor's assessment. I completed a nurturing fathers program. I engaged in weekly therapy. I also made relapse prevention plans. I showed up to all meetings, court dates, visits, FCRs. I requested and took or tried to take 3 screens a week of my own accord. An incident occurred on 7/14/20 in which a Security Notification Breach Act HIPAA violation was violated by High Point Treatment Center, and it was sent to Derek Zanini, DCF. See DOJ complaint and see court report. That incident date was cited 31 times, I believe, in the court report submitted by Derek Zanini, DCF. I caught this as it happened, and that's where this case turned for the worse. At this time is when DCF and High Point Treatment Center were going at it as to whom was at fault. Then I guess it just made more financial sense to cover each other and turn on my son and I. I have been assaulted, threatened, gaslit, and called crazy, to say the least.
So, sir, are you saying that you hadn't used substances, but there was a false positive test?
Yes.
Okay.
I've dealt with nonstop retaliation. My public pretenders would not do their jobs and did not care what the outcome of this case was, as they have no interest. They get paid regardless. As my children are the most important people in my life, I decided to start reading and learning. I'm still learning daily. I started to find multiple problems and possible illegalities in my case that I brought to my lawyer's attention multiple times. None of them would listen. So I decided it was better to represent myself if the lawyers didn't care to do their jobs. I need my son home yesterday. When I tried to get discovery, file motions, call witnesses, present evidence, I was denied, thrown out of court, threatened, and assaulted, or given redacted documents. It seems the more I learned, the worse the retaliation got. State police and local police were sent to my home, and also multiple friends and families' houses as well. I believed this to be an aggressive, isolative, threatening scare tactic to further intimidate my friends, family, and I, as they would not accept any evidence I have that I have continuously tried to turn over. The juvenile court and DCF have continuously changed the reason for their involvement and have committed multiple violations of their own laws, rules, regulations, policies, and procedures. This appeals court agreed something funky was going on in my case and basically told the lower court, get it together. However, after the mistrial, the new judge and lawyers did pretty much the same thing. During trial, I was denied discovery, was assaulted by a court officer, was not allowed to call witnesses, file motions, cross-examine, or even listen to witness testimony. I even had to call 911 to get into the courthouse after I was assaulted and thrown out of court while witnesses whom I didn't hear and could not cross-examine testified. This clearly seems to be unequal application of the laws in many different ways.
So, sir, when you were not permitted in the trial, did you have an attorney that was supposed to be representing you?
No.
And so there was no attorney that at least was appointed to try to represent you in the trial at that point?
I believe there might have been standby counsel, but they were switching out so many.
Okay.
And was this, the event you're talking about of exclusion, this is the event where the findings of fact say you were outside the building or something, or they paged you or something? There's some findings about this.
Yes, sir.
But you're saying those are not accurate?
No.
Okay.
Continue.
Please.
In many different ways. If I am crazy, why was I able to waive my rights to counsel? Parental alienation is most certainly not in B's best interest. I am not charged with a crime. Neither is B. Please read a treatise on false arrest and imprisonment. I'm of the opinion that this equates to domestic terrorism, kidnapping, human trafficking, racketeering, and RICO by definition. The requested discovery, still unobtained by appellate lawyer and myself, would undoubtedly show the financial gains by all involved with the exception of B and I. DCF nor the government do not have the power to take a child over the parent's objection. It's important to note that the supervisor, Ashley Granger, also works for High Point Treatment Center in Plymouth and had been trying to get me to switch from Taunton. Huge conflict of interest. She was upset when I refused and started to attack my counselor. She eventually got what she wanted when the pandemic and HIPAA violation occurred and sessions were held via telehealth. All new doctors and counselors and social workers were put on case, in my opinion, to close the case in support of their narrative in DCF's favor. I feel targets are placed on children whom have had DCF involvement that follow to their children, which makes it intergenerational, all for the incentives and funding that's received by the taking of children. It's essentially big business. I was left no choice but to become the belligerent claimant. I would like to quote Judge James Alger-Fee. The belligerent claimant who must make waves to preserve our rights. End quote. I mourn the loss of my living child daily. The boogeyman strikes again and profits off the family dismemberment and parental alienation of B and I, thus making it intergenerational human trafficking by way of fraud, perjury, and misrepresentation of the facts to fit the narrative to claim federal funding. I am asking you to return my child immediately and investigate the unfair trial and the other multiple indiscretions perpetrated on my son and I. I believe all the ill-gotten gains should be returned and used to help B and I heal from this catastrophic trauma. 7 minutes is not even close enough time to speak on the multiple injustices that have occurred in this case, but I tried my best.
Thank you very, very much. I think that we understand and appreciate your love for your child and how terrible this has been for you and your family, particularly given your background. So we appreciate very much. It's hard for non-lawyers to argue in court. It can be intimidating, and we appreciate your doing so. And it's true that in these cases, which we see many of, and which are the most difficult ones probably that we have to hear, 7 minutes or 15 minutes, none of it is ever enough to really adequately convey all the detail that goes on. But we do have the briefs of, not only the brief filed on your behalf, but all the briefs of the parties, as well as the transcript and the record, to help us go through and try to make an appropriate decision. So, thank you very much. Your time has expired. We will hear next from counsel for Mother.
Thank you.
If it may please the court, good afternoon. My name is Christine Hamilton-Caros. I represent the appellant Mother. Mother's case is about how the improper denial of the right to counsel for father created such a circus-like atmosphere that Mother didn't have a fair opportunity to present her case, her plan, and defend her rights. In the ordinary case, Mother would not have standing to raise the issue of waiver of counsel to Father. However, this is not the ordinary case. This is an extraordinary case. Mother, the circus-like atmosphere created by the judge by not following the rules created such a chaotic environment that Mother could not hope to defend herself against the state.
So could you elaborate on what it was that created a circus-like atmosphere, or what the atmosphere was?
So from the very beginning of trial, it was apparent that Father was not in the state of mind on that day to represent himself. The judge even found that during opening statements, he was presenting as if he was someone off of his mental health medication. That's not someone who's in the frame of mind to waive counsel. And rather than refer to the rules, which there are rules that are very clear, this court has followed them, that inquiry needs to be made into Father's ability to represent himself. The judge did say that he's unwilling to represent himself, so he's not going to, unwilling to accept an attorney, court-appointed counsel. So the court's not going to appoint counsel. However, that's not the standard. The standard...
How did that impact your client?
That impacted my client because he was her plan. Her plan was Father was temporarily unfit, on his way to fitness, and with a little bit more time, and if he had had counsel, any sort of disruptions, he would have been asked to leave. The attorney could have presented his case. He has a support system. There was no opportunity to present that because Father didn't have counsel. He was asked to leave the courtroom. He left the courtroom on his own after warnings. He disrupted trial. Had he had an attorney, the attorney would have remained in the room, heard all of the evidence. Standby counsel, there were times standby counsel wasn't in the room. Standby counsel was outside of the courtroom with Father.
With the father?
With the Father.
Okay.
And
When Father was in the courtroom, was the standby counsel there?
the record seems to indicate that standby counsel was there when Father was there. However, had he had an attorney when Father was asked to leave or voluntarily left because he needed a break, the counsel would have gone forward and been able to present his case. No one was there to present his case because there were times Father was asked to leave and standby counsel was not in. When he came back, he did ask. He wanted to present witnesses. He wanted to cross-examine witnesses. All of that was foreclosed to him.
Counsel, could I interrupt? And I apologize for doing that because I think you may still be answering Judge Henry's question. But does the mother challenge the finding of unfitness on her own case?
So in the brief, in Mother's brief, Mother argues temporarily unfitness, but that's not the purposes of today's. Today, Mother wants to focus on the legal argument that requires a remand.
So my question, though, is to the extent that Mother was prejudiced by any view that the judge may have taken of Father's fitness, her efforts at the time were limited to obtaining visitation with the child. Is that correct? Or parenting time with the child?
I apologize, I don't understand. Could you rephrase?
My understanding is it wasn't an issue that, or I understand your argument to be, and correct me if I'm wrong, that the mother was adversely impacted because the judge was finding Father unfit and based on certain procedural irregularities. Am I right so far?
Yes, Mother's case is based on the fact that she was prejudiced, and she filed a motion to ask the court to recuse. She was prejudiced because Father created such an untenable environment that it's really unreasonable to expect Mother to be able to assist her counsel or the other attorneys to be able to put on a case in that sort of an environment. Father was unraveling in front of everyone's eyes.
So your argument then is that the circus-like atmosphere impacted Mother's ability to present her own case, not that it impacted Father and thus impacted her. It
would be both. It impacted her ability to defend herself, in the fact that she was temporarily unfit, and it impacted her plan, which was for father to be reunified with the child because he was temporarily unfit at that time as well. And
So what does mother contend should have happened?
that the court should have stopped the proceedings, made an inquiry into father's ability to waive his right to counsel, and she believes he would have been appointed counsel, and each case would have been fairly presented. Mother would have had a fair opportunity to present her case. Father would have had a fair opportunity to present his case, and they would have been found temporarily unfit.
Appointed counsel against his will.
Judge, it's not, respectfully, it's not, the standard is not whether it's his will, it's whether he's competent.
I understand that, but that's what we're talking about, because my recollection is that several lawyers were appointed during the proceedings below, or am I misremembering this?
Judge, father was appointed one attorney for almost the entirety of the case until, and this wasn't argued in my brief, but
Yeah.
until, it is in the record, until, I believe, until the motion for mistrial was filed, because everyone was in agreement that father was going to be the plan, even the department, and the judge took it upon herself to say, you know, I'm maybe misquoting, but in summarizing, paraphrasing, you know, if a parent has substance issues and is using, I'm going to.
I remember that.
So that's the point where everyone was in agreement, and father, understandably, as the court had mentioned, these cases are difficult to understand, they're very complicated. This to him sent a message that I was told something, and now what my attorney, the opposing counsel's attorney, said to me was wrong. It's a bait and switch, and they're so.
Yes, I understand.
Yes. And so at that point, father said, I can't trust the attorney to represent me. And he did ask for another attorney. But for mother,
No objection was made below by mother to the adequacy of his waiver?
mother filed a motion to recuse and for mistrial based on the fact that she didn't think that she could get a fair trial after accusations started with the father and.
But you didn't, here you're saying that there was an inadequate inquiry into his competence to represent himself, but that was not raised below.
Not by mother's attorney.
Okay. Your time has expired. I see no further questions. We will
Thank
hear
you.
next from Attorney Carbonaro.
Good afternoon. May it please the court. My name is Allison Carbonaro. I'm an associate with Latham & Watkins, and I represent the Department of Children and Families in this matter. Today, the department's request is twofold. First, we ask this court to uphold the trial court's decision to terminate mother and father's parental rights. And second, we ask the court to uphold the trial court's decision regarding post-termination visitation in this matter. On appeal, mother and father do not challenge the vast majority of the trial court's findings of fact against them. Therefore, there is a constellation of undisputed factors that clearly and convincingly establishes that both parents are unfit and termination of their rights was in the child's best interest. These unchallenged findings alone are more than sufficient to establish their unfitness by clear and convincing evidence.
Well, but up until April of 2021, if I understand it correctly, the department's position was the father's a great dad. We're going to put this kid back with him. Right?
So if I may put a finer point on it, Your Honor, the department certainly had concerns, but
Sure.
the ultimate goal was reunification. That is correct. However, given,
And the department was working toward that.
yes, and the department
And
and
then I
father.
gather something happens. Maybe it's a reaction to this mistrial. Maybe it's a mental health issue being or becoming either worse or untreated. Maybe it's a substance abuse issue. I don't know what it is, but the department at least begins reporting pieces of behavior that are obviously very concerning.
Yes, that is correct, Your Honor.
What makes you think that those will continue indefinitely into the future if literally months before they didn't exist? What makes you think they're permanent?
So it's not the department's position they didn't exist, Your Honor. It's that the father was attempting to make strides, and the department was,
But he was adequate until this stuff started happening to be someone you were going to return the child to. Then things happen. And I'm trying to figure out how it can be that someone who's on track to get their child, I mean, there's lots of ways it could be, but someone who's on track to get their child, you're not reporting in complete things about taking the kid to McDonald's, and locking the car doors. And there's, so far as I can see, there's nothing like that before April 2021. And then that starts. And I'm not saying that's not adequate to terminate parental rights. The question is, what makes you think it's not going to stop, particularly since I don't think you even know what's causing it?
so, Your Honor, the father's mental health issues, and it's clear from the record, certainly declined rapidly starting in the spring of 2021, but the department has been involved with this family since before the child's first birthday. He's 8 years old now. And when we look at the pattern of father's conduct over the last 8 years, it's clear that there were concerns about his mental health issues. Starting back in 2015, father was engaging in, or allegedly engaging in manipulative and controlling behavior towards mother. Father was suffering from suicidal ideations in 2016. The record is replete with examples, even before 2021, of father struggling with his mental health issues. There are
DCF was very content with him until April of 2021. When was the trial held?
So the first trial in this matter, Your Honor, was held,
The real trial.
so it began in November 9th, 2021.
Okay, so 7 months after these symptoms begin is when the trial is. And the court has to find clear and convincing evidence that these things will continue indefinitely into the future.
Yes, that is correct.
And what is the basis for that finding?
So the basis for that finding, Your Honor, is, as I said, the sort of rapid decline that we see starting in April of 2021, and the department would argue that that is characteristic of a longer pattern of behavior, that yes, that behavior got substantially worse.
Rapid decline is characteristic, you don't mean as a diagnostic matter?
No, not of a diagnostic pattern, Your Honor, but it's...
Don't you need a diagnostic, don't you need someone to say, well, when this happens, this is a kind of thing that...
So I'm not sure I'm understanding your question, Your Honor.
I'm just asking about, someone has some mental health issues, let's say, and then things get dramatically worse. And maybe they're currently unfit as a result of them. I mean, even apart from this case where they're a pre-existing, just a person, and the child is taken away. Before you can terminate the parental rights, you have to be able to prove that this bad situation then will continue indefinitely into the future, or at least that they'll be unfit indefinitely into the future.
So, yes, I understand, Your Honor. And so,
Okay.
as I've said, there's clearly, father was suffering from mental health issues, at least as far back from the record as we can tell in 2015. Yes, as I said, those issues got substantially worse, but father was engaging in therapy and was, there's evidence in the record that his therapists were trying to help him process what was going on with his child, at least far back as 2018. So it's clear that these mental health issues...
But if this decline reversed, let's say he had this terrible rapid decline, you called it, in April. But by June, he's back to where he was. It turned out he wasn't taking a medication or this or that. Surely DCF wouldn't be able to say, well, he's unfit because he had an episode. I mean, they might be able to, but I think you'd have to show more than that. And what I'm trying to figure out is, do we know if this is an episode or it tells us the picture about the future?
So, Your Honor, it's DCF's position that this is not evidence of an episode, but again, is characteristic of a pattern of behavior. And given that, and evidence, and as this court has held in adoption of Alona, because childhood is fleeting, a parent's unfitness is not temporary. If it is reasonably likely to continue for a prolonged period or an indeterminate period.
Did you bring in a mental health expert to explain why this would last for a long period?
No, there wasn't a mental health expert at trial, Your Honor.
Can I ask one question?
Oh, of course, sure.
Was there a change in the father's access to or use of services during the period immediately preceding or during what you're talking about as a decline?
So prior to trial, it's my understanding, Your Honor, that father was declining to use services. Father had access to those services from DCF. However, he was not engaging in therapy, refused to engage in a mental health evaluation, and was not regularly following up with counselors as he had been in the past at the time of trial.
And when you're talking about the second trial,
Yes, the second trial, Your Honor.
So I guess my concern, though, is, we had this unusual situation where the father just, first of all, do you agree that he discovered at some point that the trial judge, the first trial judge, kind of blindsided him by, changing to intend to consider termination, or do you disagree with that characterization?
No, we don't disagree with that, Your Honor. I believe that the case law...
I want to make sure you don't disagree.
So I don't disagree that the judge changed the goal. I don't know that I agree with the characterization that father was blindsided. Certainly, it's unfortunate that father found out the way that he did, and we...
You mean rather than by having a notice sent out?
Yes, and I believe DCF did support, didn't oppose that motion for mistrial for that reason.
What I'm trying to understand is, did that contribute in any way, the judge changing the goal or intending to consider termination, did that play a role in the father's mental health decline?
It very well might have played a role in the decline, Your Honor. However, I would argue that that's outside the record, given that we don't have expert testimony that's able to explain that.
What we have is that B followed A, which I realize does not always mean that A caused B, but sometimes it does.
So yeah, I think it's fair to say that, yes, that was, there was, the issue with the first trial judge, there was a mistrial, and then we see this sort of rapid decline. I think that timeline for sure is supported by the record. I would argue that, again, as you said, B doesn't necessarily, or A didn't necessarily cause B in this regard.
Doesn't it make it harder for you to show that it's going to continue indefinitely into the future?
So I do think it makes it, I don't know that it makes it harder, Your Honor, so that it will continue indefinitely into the future, because there is so much evidence in the record. The father has had this long, significant history of mental health issues. I said stems back at least as far as 2015.
But he was good enough with that history to have the child until April of 2021.
So there was the possibility of reunification in April of 2021. Father was still on trial for unfitness. His fitness was still being called into question, and DCF was still prepared to go to trial to show that father was unfit. The only thing that changed was the ultimate goal, whether or not father might be able to be reunified with the child one day in the future, or whether or not adoption was a more appropriate goal for this child. And given father's rapid decline, and given all of the other factors at play that father does not challenge, such as his unstable housing, history of domestic violence, and all of those other constellation of factors that are laid out in the department's brief.
When was the last time the child was in the custody of either parent?
So the child has not been in the custody of either parent since, let me check the exact date, Your Honor. The third removal occurred in April of 2019. So I see that I'm coming up on my time. If the department has no other questions, we will ask that that this court upholds the decision of the trial court in this matter, and the department will rest on its brief. Thank you very much.
Thank you very much, and we will hear finally from Attorney Paquin.
Members of the panel, may it please the court. Nicole Paquin on behalf of the appellee child, who asks that you affirm the juvenile court's order. In this matter, the best interests of the child require termination of both parents' parental rights and affirmation of the court's order for post-termination visitation. I'd like to address father's fitness first before touching briefly on mother's. It's been said that, or been argued that father's unfitness began because of the unfortunate first trial and the judge's undisclosed change of the goal. However, the evidence shows that father's deterioration actually began long before then. He first tested positive for fentanyl use in September 2019. There were numerous positives in September, December 2019, January, March, and October 2020, and then again in September 2020. Now,
when was the allegedly false positive test?
Father argues that all of those are false positives.
I thought there was a single test.
The record shows that father began arguing that all of those positives were false. By September 2020, the department had concerns about father's mental health, and he was refusing a psychological evaluation. By December 2020, he was noted to be perseverating on these drug tests, alleging that he had been blackballed by the department because of these alleged...
Well, look, if you're having your children taken away from you, it's because of a drug test. I don't know why we would call it perseverating to be focused on it, but all right.
He was noted to be very aggressive and ranting about these accusations. It's unclear whether they were false positives.
Of course.
By January 2021, the foster mother with whom the child has lived since his third removal in April 2019 was no longer willing to host visits because father had deteriorated to the point of being rude, disrespectful, and was making the foster mother, who is his sister, very uncomfortable, and she no longer felt comfortable being alone with him. I understand the argument that the mistrial impacted father's mental health. However,
Was the sister originally proposed by the father?
I do not believe so.
Okay.
But the child has been with her since the time that she was removed. The child is thriving there, and he wishes to stay there. At the time of trial, the foster mother, the aunt, was in the process of being approved for adoption. She seeks to adopt the child.
Have you met with your client
Numerous times, Your Honor.
face to face?
Yes, Your Honor. I have met with the child 6 times. Twice, unfortunately, had to be virtual, but 4 times in person for a minimum of an hour, often much longer.
How recently?
In March 6th, I met with him in person. Due to scheduling issue, I ended up meeting him via video call again in April 7th.
And I know this is outside the record, but you're telling us that the child is still in that placement.
Yes, he is still in that placement. Father's unfitness, the period of father's engagement with the department and progress was actually an aberration. Father has twice overdosed in the presence of child. Child has complained to his teacher that he made him nervous because he gets mean and angry. The child also complained that he needed to teach his father how to drive because he falls asleep in the car. The child has also noted that father has fallen asleep and child was unable to wake him. The child deserves better than this. In the case such as this, fathers' and mothers' rights must not only be weighed against the societal interests of resolving this matter, but also against the child's rights. In the best interests of the child, mandate that mother and father's parental rights be terminated at this time because he deserves stability and permanence, and that is what he seeks. I know I'm just about out of time. I would like to just very briefly address mother to say that she did not object at the trial to any of the alleged chaos and did not object to the waiver of father's counsel at trial.
So what was the basis then for the mistrial? Didn't she move for a mistrial?
She moved for a mistrial because after the first day of trial, the department's counsel had a conversation with father outside of trial, in which father made some statements. DCF, the department filed a motion seeking to substitute counsel on the basis that those statements by father were allegedly threats and that counsel could not continue to represent her client. Mother did not object at that time to the substitution of counsel. The judge allowed that motion to substitute. Later, mother filed a motion for mistrial and recusal, alleging that since the trial judge had, according to mother's counsel, or according to mother, found that father had threatened the department's counsel, that she was now biased and could not continue with this trial. However, the trial judge found that she had made no such finding as to the substantive claim that father had actually threatened counsel, only that the department deserved to be able to substitute counsel. And that was the basis of the mistrial. and the recusal.
Okay, thank you very much. Very helpful arguments from all of you. As I said before, these are probably the most difficult class of cases we hear because of the difficulty for all the people involved. So thank you very much for all of your help with that. I'd like to thank the court officer and court staff for all their help with the sitting. And the case is submitted, and we will stand in recess.
All rise.